So the first change that is going to occur as a result of this bill passing is removal of the word unanticipated from our parenting plan modification statute. Prior to this new law coming into play and being passed, you had to prove that there was a substantial, material, unanticipated change in circumstance in order for you to proceed with a modification. Once you proved all of those things have happened and have taken place, then you move on to best interest. So we've now removed the word unanticipated. So now, as long as there has been a substantial and material change, whether it was anticipated at the time that the original parenting plan was entered or signed or agreed on, or whether it was not anticipated, you still have the ability to move forward with a modification as long as there's been a substantial and material change in circumstances. Once you prove that, then you'll move on to the best interest factors. Okay, so up as number 2 on the new bill and changes to our timesharing statute, there is now a rebuttable presumption of 50-50 timesharing. So remember, this is not related to the paternity stuff that I talked about in another live. This is literally just a change regarding the parenting options and parenting plan. So this would apply immediately to anybody who's married and paternity cases where we have paternity established. So once paternity is established and we're dealing with timesharing, judges now are going to need to presume that we're doing a 50-50 schedule. If you don't want a 50-50 schedule, if you feel like a 50-50 schedule is not in your child's best interest, it's a rebuttable presumption, which means that we can rebut it. And we would rebut it by showing that the 50-50 schedule is not in the child's best interest. We're going to do that by going through the factors that are in the statute. And that kind of ties in to the next part. So part 3 of the new bill and the changes that have been made is that at this point, when a judge makes decisions about parenting plans, they don't have to back that up with specific analysis of the factors of best interest that are in Chapter 61. Now, with the new law starting July 1st, for a judge to enter a timesharing schedule, the judge is going to have to take into consideration all of the factors that are in our best interest statute and make written findings of fact about each one of those factors. That's different than what we had before. So this does not apply if you all are agreeing on something. So you can agree to do something other than 50-50. You also can agree to something that is not necessarily in alignment with those best interest factors in the statute. But if you don't agree and it goes in front of a judge has to start at 50-50, listen to evidence that rebuts that would be in the child's best interest, and make written findings of fact on each of the best interest factors about how those factors are playing out in your case. Finally, this new bill makes another change regarding relocation. So if at the time your parenting plan was either ordered or entered, you lived more than 50 miles away from one another and therefore have some type of a long distance schedule, you now move within 50 miles of the other parent. That is a basis for a petition for modification. So that amounts to a substantial unanticipated circumstance that would allow you to file the petition for modification. You're still then going to need to go through best interest and the best interest factors, but it gives you the ability to file for a modification if you move within 50 miles of the other parent. Let's start breaking down all of these changes to Florida law. So first of all, with the new presumption of 50-50 timesharing, that is going to apply to married couples, and it's also going to apply in paternity cases when parents have not been married, as long as the dad's name is on the birth certificate or an acknowledgement of paternity has been signed. The acknowledgement of paternity is what puts your name on the birth certificate. So if your name's on the birth certificate, it's a pretty safe bet that you've signed one and the 50-50 presumption is going to apply. Secondly, you're going to be able to overcome that presumption if you have circumstances that would make it not in the best interest of the children in order to do the 50-50. But it's going to be your job to prove that, because the court is going to start with a 50-50 presumption. Next up, I don't want you guys to forget that it's not an automatic 50-50 timesharing. It's a presumption of 50-50, but you're still going to need to file the petition for paternity if you're a dad. You're still going to need to be able to get in front of the court and get an order establishing your rights to 50-50 timesharing and establishing a schedule for 50-50 timesharing.